We cannot allow a Soros prosecutor and a conflicted Democrat Biden donating judge, acting judge, to make a decision that in fact impacts the entire nation, destroys our electoral system, and destroys our political system. They call it lawfare. They can call it whatever they want. I say it's tyranny. And if we don't stand up to it, shame on us.
This is where freedom rings.
If you believe in America, if you believe in the Constitution empowers us. It's a new day. America's back. America's back, and America's going to get strong again. We're going to defend America, and we're going to defend our interests.
Liberty's voice, Levin TV.
Hello, America. I'm Mark Levin, and this is Levin TV. I believe it'll be a historic Levin TV because we will address what took place in the Manhattan courthouse in a way that I think my background and experience and personality are uniquely qualified to do. No brag, just fact. I'm not a conga line lawyer. I'm not an assembly line lawyer. I'm not a former federal prosecutor, and I'm not a theoretician, although from time to time I can be. The purpose of a lawyer is to do what? To advocate for his or her client. Not to throw their hands in the air and say, well, here we are, we're stuck, justice delayed is okay. No, justice delayed is justice denied. You remember that old statement? Well, we got to wait for the New York appellate courts to decide the fate of the nation. Unfortunately, they won't decide it in time for this election. That's not good enough for me. It shouldn't be good enough for you, and it shouldn't be good enough for the United States Supreme Court. We cannot allow one prosecutor and one judge to potentially change the outcome of this presidential federal election. People keep focusing on what the jury did. There'd be no jury but for this prosecutor and this judge and their reverse federalism. That is, to have effectively a local prosecutor and an acting appointed state Democrat conflicted judge in collusion with the Soros prosecutor seizing federal authority, not just over federal campaign financing laws, but over a presidential election, the most important office in the United States, 1/3 of the branch of the federal government. We cannot allow a Soros prosecutor and a conflicted Democrat Biden donating judge, acting judge, to make a decision that impacts the entire nation, destroys our electoral system, and destroys our political system. They call it lawfare. They can call it whatever they want. I say it's tyranny. And if we don't stand up to it, shame on us. Shame on us. What is the job of a lawyer? Is the job of a lawyer to go on TV and say, woe is me, we have 4 billion violations of due process. Let me show you how smart I am. When I was in this courtroom, when I was in that courtroom, we've never seen anything like this. I've had prosecutor judges, but not like this one. Or where's the verdict form? And all great and all important, but right now all irrelevant. If in fact the appellate process in New York doesn't resolve this matter and resolve it correctly until after the election, the entire point of what took place in that Stalin Star Chamber was to affect the election. That is, the reason all these violations of due process rights, all these violations of evidentiary rules, the reason the jury got the instructions that it got, the reason this case wasn't dismissed at the outset, or at least dismissed on summary judgment on some basis, the reason why we don't know what the predicate crime is, we only know in an amorphous way it's a federal campaign violation. The reason why all these things took place, that Brad Smith couldn't testify, that Robert Costello was brutalized by the judge in front of the jury, that Michael Cohen could testify to anything he wanted to without a collaborating witness, that Stormy Daniels did her fan dance in front of the jury. The reason why collateral evidence was allowed and the reason why all these things took place was to affect the election. That's why it took place. The timing was to affect the election. And so now people are saying, well, the American people need to get angry. Of course we're angry. They don't need to tell us what to do. You and your heart and your soul and your head, you know what's going on. You were probably very, very upset. You can't believe it's taking place. You talk to the people who are closest to you. They can't believe it's taking place. What's happening to our country? What are we going to do? That's the political side. What are you going to do? You're going to organize. You're going to become the greatest activist you've ever been. You're going to do more than you're doing now. If you have money, you're going to donate to the campaign. You're going to do whatever you have to do in your own role, in your own life, whatever you're capable of. But one thing you cannot do is do nothing. But that's not the point of today's program. If you're a lawyer advocate for your client, do you throw up your hands and say, well, we'll go up the appellate process in New York. We're stuck in this lane. We'll hope for the best. Maybe it'll be reversed. But we can't get it done before the election. So you've lost. You've lost. They won. And that will serve as precedent for 1,000 other local and state prosecutors. And this destroys the national campaign process, federal jurisdiction, that began really around 1971 with multiple amendments to FECA, the Federal Election Campaign Act. We don't know what the law is now, or is there a law? We don't know what the basis is for charging people. And this is the precedent that we're going to allow because one Soros prosecutor and one corrupt Biden-supporting judge, acting judge, make this decision. 2 people, not the jury, 2 people. And we're going to allow a blue state, New York, to determine the outcome on its watch during its process. Even at the end of that process, they say, everything's being thrown out, so forth and so on. The issue is you, the electorate. The issue is we, the American people. This is an attack on us, on our right to hear from Donald Trump, on our right to go to a rally to hear what he has to say, on our right to meet him. According to the so-called experts who are really phony, but people who look at the data, this election is going to be decided by a handful of states and a relative handful of people. The last election was decided cumulatively by less than 50,000 votes in key states. The 2016 election was decided by about 100,000 votes in key states. You're going to have perhaps, give or take, 150 million voters. That's a tiny fraction of the voting population. And I'm not even getting into the issue of whether this is going to dispirit enough people or not. I get tired of the Pollyannas out there who say, now we're really going to win. Now the turnout. I hope so. I cheer for it. Only you can save the country, but that's always the case, especially now. But that doesn't mean you give up on other possible avenues of addressing tyranny, the tyranny of the Democrat Party, who's destroying our electoral system, destroying our constitutional system, to destroy Donald Trump so you can't vote for him, or to drag enough people on the fence away from him to maybe Robert Kennedy or somebody else, or maybe Biden or what have you. We cannot allow tyranny to persist because it'll devour us. And that's what's happening right now. We wouldn't have all these cases but for the Democrats, the Democrat Party, Biden, and the Biden regime. We wouldn't have issues of immunity in front of the Supreme Court. We wouldn't have issues of the Espionage Act and documents in front of a federal court. We wouldn't have issues of RICO. We wouldn't have issues of we're not even sure that took place in Manhattan, but for the Democrat Party. They are simultaneously attacking one of the leading conservative justices on the Supreme Court, Alito, all timed, having done a drubbing on Clarence Thomas a few months earlier, and a warning shot on Neil Gorsuch a few months before that. This is all intentional. Now, we lawyers come in different flavors. Some have experience that's limited to federal cases, federal trials at the litigation front end of the process. Some come as defense lawyers. That's all they know. Maybe they were former federal prosecutors. Some come as former federal prosecutors who are defense lawyers and professors. It's all good. I come to this as somebody who has spent 40 years in the constitutional conservative movement, a phrase that wasn't even used until I started using it about 20 years ago on radio. They had divided conservatism into fiscal conservatives, foreign policy conservatives, social conservatives. I said, whoa, 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 whoa. What do we all have in common? We're constitutional conservatives. A phrase that predates me, but had lost its appeal. And so I breathed life back into that phrase. We're constitutional conservatives. That's very, very important to understand for another day, but I think you intuitively get my point. If we're constitutional conservatives, do we sit by and say we'll leave it up to blue state New York, radical left-wing lawyers, radical left-wing prosecutor to determine what the federal Constitution is? Because that's where we are right now. That's where we are right now. We don't even know what the hell actually happened legally in that courtroom. So lawyers are scratching their heads. So that's one lane, if you're an advocate for President Trump, in my humble opinion, just me, that you need to preserve. That is, you go through that process, but you try and speed it up. You file an emergency appeal. You use whatever processes are available in New York. I'm not a New York lawyer. I'm a Philadelphia lawyer. We like to think we're better, but it doesn't matter. And so whatever process you can use to speed it up, and you seek a stay in the lower court. You might win, you might lose. That's the nature of litigation. I don't know if we'll win or lose the election. People keep saying to me, but what if the court says, okay, what if the court says you've got to bring something to the door of the court? You have to be a petitioner for the court to take something up. The court can't on its own sit there and say, hey, we saw what happened there. We're getting involved. The Israeli high court works that way. Our court system does not. Furthermore, look at the other side. Do they say to themselves, you know, this ballot removal or ballot blocking initiative doesn't have a chance in hell, so we won't do it? No, they say, do it. They don't say, look at Manhattan. We're going to bring 34 charges. We're not going to provide the details of the predicate offense that breathes life back into these cases. Even though the FEC said no, even though the U.S. Attorney's Office said no, even though Cy Vance, the former DA, said no, even though Bragg initially said no, we've decided we're going to say yes. Do they sit there and worry about whether they're going to lose? No. This wasn't even a colorable case. It's a preposterous case. And they won because the fix was in. One source prosecutor, one conflicted Biden-supporting judge. Do we allow this to stand? Do we say, okay, look, in all my years as a federal prosecutor, all my years as a defense lawyer, and all my years practicing in it, no. As New York goes, the nation need not. And so with this in mind, what do you do? If you're a good lawyer, if you're an advocate, if you have experience in your background fighting these people, you don't surrender. Even if the whole thing is reversed and eventually thrown out after the election, they've won. They've affected the election. Even if Donald Trump wins, they've still influenced and interfered in the election. That's where the law stands right now. What do? You look for some kind of pathway out of that lane where the fix was in. We are now relying on a Democrat state and appellate courts, which may give you what you want, but too late. The issue here is our presidential elections, federal jurisdiction, and a cohesive electoral policy that applies throughout the states. It is a federal election. We talk about federalism, state authority. This is reverse federalism. I call it, where a state has seized the authority from the federal government on the election of the highest official in the land, the President of the United States. That's unconstitutional. That's unconstitutional. Just on its face, right there. Everything else falls away, but it didn't. So which is the court? That if you can get it to the court, if you can find a procedural pathway to the court, which is the court, and the only court that has national authority over a presidential election if the Constitution is violated? It's the United States Supreme Court. So you look at that, you say, okay, has the Supreme Court ever intervened in a federal election when it thought the Constitution was violated? Yes. It's called Bush versus Gore. Bush versus Gore. Almost 24 years ago. Okay, then you read that decision. What did they say? Well, there were split decisions, but 7 of them did vote on the application of what? The Equal Protection Clause. The justices decided that they needed to take the case out of Florida. The Florida Supreme Court, their highest court, kept changing the election laws. The deadline was coming for Florida to file for its electors. You have a deadline because there's a constitutionally specified date when Congress meets, all of Congress, in a joint session to count the electoral votes. And so states have deadlines. They file their electoral paperwork that has to be certified by the governor under federal statute with the archivist of the United States, who prepares it all and presents it to Congress when they meet. And in the past, there have been occasions when there have been a separate set of electors. Congress has the constitutional power to sort that out. Not a grand jury, not a special counsel. That's a footnote. But anyway, so what do? You have complex federal campaign law. You have a constitutional system that deals with federal elections. You're talking about a federal office, the highest in the land, the President of the United States. Do you leave it to Allen Bragg and Judge Merchan? No, you don't. So you look at Bush versus Gore. What did the court do? First of all, it determined that a presidential election is important enough that they decided to get involved. Okay, that's a positive, right? Secondly, you look at their rationale. They got involved ultimately because they settled on the doctrine of equal protection. It's in the Fifth Amendment of the Constitution that applies to the states through the 14th Amendment to the Constitution. It's part of the Bill of Rights. And so you look at Florida, and what they said is, the majority, the curiam decision, they said, look, you folks have changed the election law so much that voters in one county voted based on one idea or one legal standard, and voters in another county voted on another legal standard. Hanging chad's okay in this county, not in that county. Then it goes to the Florida court and they say, okay, we're going to do this, we're going to do that. And the Florida court is doing things that violate the state legislature's legislation, which is primary under the Constitution, not the state court. In other words, the Florida Supreme Court is amending the state legislature's election laws to the detriment of the voter. So the Supreme Court said this affects a national election, the election of the President of the United States. This is too important to wait. And the deadline is near. And so we have determined to end the vote count that's taking place in Florida right now. We've determined that voters have been treated unequally under the 14th Amendment, the Equal Protection Clause. And so you have the decision in Bush versus Gore that put an end to the counting, which resulted in the electoral votes in Florida being assigned to George Bush. I look at that and I say, okay, are the facts the same? Not exactly. But we have a number of things going for us. Again, they decided to take up the case because they determined it's an election for President of the United States, and in my language, this state is screwing around. This court is screwing around. But they couldn't take up the case unless what happened first? Somebody brought it to them. Who brought it to them? It's Bush versus Gore. The Bush campaign petitioned the court. The Gore campaign responded with their petition, their answer. But the court couldn't stop what was taking place if it wasn't asked. And what were the chances of the court getting involved? At the time, people thought small to nothing. But that's not what happened. The court took it. So what is the pathway here? My argument. You have a violation of due process under the 5th and 14th Amendments. You've been watching Fox or listening to me for 6 weeks now, and there's so many examples of due process violation, they're almost impossible to compile. They feel like they're infinite. And that's the point. What was the point of all these due process violations? To influence the election. How? How? To get a guilty verdict. To get a guilty verdict. And so, while you're in the one lane trying to overturn that guilty verdict, you're in this other path you're trying to create to the steps of the Supreme Court and figure out what arguments can you make that might persuade them, even if you have a 10% chance. Okay, well, we have Bush versus Gore. So we want to basically stay as close to that as we possibly can, even though there are some differences. But the similarities are what you emphasize. First of all, you have a situation where you have a prosecutor and a judge that is a state court seizing federal jurisdictional authority in a federal campaign, and not just any federal campaign, the most important federal campaign that the nation holds. That is the campaign for President of the United States. That's number one. Number two, you have a myriad of 5th and 14th Amendment due process violations against the putative Republican nominee, the former president, who will be the Republican nominee, thereby effecting the ability of the Republican Party, members of the Republican Party, donors, and the candidate himself to participate as equal participants in a presidential election. But the due process also flows to you and me. When they are unable to participate in a normal and routine manner in a presidential campaign, that affects you and me, Mr. and Mrs. America, the citizen, the voter. We don't have access to the candidate. 5-6 days out of the week, we can't hear from the candidate. Maybe we want to go to a rally to meet the candidate. Maybe after we meet the candidate, that'll make our decision to support the candidate. There's, you get 1,000 possibilities when you're running a campaign. The fact is that the campaign is handicapped. I don't care when people say, but his poll numbers go up, but it's irrelevant. That's a snapshot. We don't know what the end result's going to be, but we do know what the result is now, that one campaign can campaign unfettered and another campaign is shackled, or at least was, for 6 weeks. For 6 weeks. And that judge is not done, depending on what the appellate courts do in New York. Maybe he won't stay a sentencing. Maybe he'll issue a sentencing that's problematic. The problem throughout this is they've created a scarlet letter, which that candidate now has and carries into the entirety of the election, and which his opponent is going to use. Convicted felon, Donald Trump. Convicted felon, presidential nominee. Convicted felon. They're bragging about this. They're giddy about this. The media, same. So obviously, I will put it my way. This doesn't help Donald Trump. Well, we got in more money. No. But in the long run, you don't know the impact. And the impact is, if Donald Trump had a choice, would he have gone through this or not? Of course not. Has he explained that this is corrupt, it's campaign interference? Yes. He wouldn't say those things if he thought it was going to help him, would he? So all the static aside, you're the advocate. You're trying to get to the Supreme Court. So you have this due process issue. You have the interference in a presidential election. Okay, we've got some patina, or actually more than a patina, of the Bush versus Gore precedent from 2000. And you have equal protection arguments that you can make as well. What are they? The ones I just said. One campaign versus another. One campaign unfettered, another campaign shackled. Okay, great. Now, how do you get to the Supreme Court? Well, you can follow the New York rules, and you can follow the statutory process, even at the federal level. New York rules is you have to finish all your appeals. Well, that won't work. That won't work because, what did I say? The purpose of this entire thing was to interfere with and affect the outcome of an election by a single prosecutor and a single acting state judge in a blue state who both are all conflicted up. That's number one. Number two, what about all the other prosecutors in all the other states? Is it now freebie time to take your shots at a presidential candidate, particularly in a heavily partisan jurisdiction? How do you get this to the court? Well, you can't wait for the appellate process then in New York. Well, you have a writ of certiorari. That is, you can ask the court, okay, court, look, we've gone through the New York process and so forth. You're the court of last resort. Look at all these violations. The New York court didn't rule the way we wanted to, or its ruling actually was okay in terms of our client, but still whether you can do that, wait till after the election, which defeats the purpose. But you still want to preserve those appeals. Why? Because you're building a path to the Supreme Court that the Supreme Court may not entertain. You still have deadlines on the appellate process in the state. You don't want to blow through those. So you still need to do that for your client. And ultimately, if the best thing you can do has to be done after the election, then it's done after the election. But you don't have to just stand for that. So you try and build a path to the steps of the Supreme Court. Well, this writ of certiorari won't work. Why? Well, the state court's not done. And I can find no federal statute that provides for a path to the Supreme Court, a runaround, an end around. But there is a way. And I've spent time digging into this, and I've sought the advice of one or two people who I trust. And let me tell you and read to you what I posted on social media last evening. The issue is now to get out of the New York system and bring the case to the Supreme Court, which may or may not take it up. That second lane. This is why I looked to Bush versus Gore, where the Supreme Court decided to step in because it was a presidential election. And I would argue, if I were arguing this to the court, this is even more critical. Because in the Florida case, the Florida Supreme Court wasn't claiming federal jurisdictional authority over federal campaign law in a federal presidential election. It didn't even come close to that. It was mucking around within the state. What this court did is it reached into the federal government and said, you know what? We're going to take that. We don't even know what that is, but that's a secondary point. We're going to take that and use it to revive our state statutes to affect a presidential election, right? It's even worse in my view. So I look at Bush versus Gore, where the Supreme Court decided to step in because it was a presidential election. There was another court involved, as I explained, the Florida Supreme Court and so forth. In New York, you would file the notice of appeal to preserve your right to appeal and ask for a stay of the trial court. Stay the sentencing while you are considering the case. And I would file an emergency notice of appeal. I'm not familiar with the New York procedures, but New York lawyers know how to do this. It's not brain surgery. They open a book and they read it. And I would seek from that New York appellate court an expedited or emergency review. Then I might file applications for the common law writ with the U.S. Supreme Court, where the Supreme Court can take action if it chooses and legitimately claim the harm is immediate and ongoing, I would argue, but that the federal electoral system, the federal campaign jurisdiction issue, reverse federalism, as I discussed, and the precedent that it might create through the back door if left unchecked. There's already a bad precedent. What is it? That people are sitting around waiting for one state to decide the fate of a presidential candidate. That's already bad precedent. The fact that we're in this court going up one state's chain of appellate process, that appellate process, if it's not challenged, is binding on a federal presidential candidate, and that state appellate process involves federal law, the whole thing is screwed up, and we have to wait for that to finish. The fact that it's taking place is fact enough to seek a Supreme Court intervention. So I told you a writ of certiorari won't work. That's the way 99.9% of cases are brought to the Supreme Court. So what do? It's something called a common law writ. A common law writ. What is that? It's a judicially created, if you will, writ. It goes back many centuries. It goes back into British law and so forth, or British common law. A judge looks at or justices look at what's presented. They say, okay, it's not a writ of certiorari, we know that. We know what a common law writ is. We've seen these all the time and reject them all the time with rare exceptions. But this is now giving us an opportunity to take up this case as the Supreme Court. As the Supreme Court. I would argue, not just as an appellate court, but as the Supreme Court, to examine this for a multitude of reasons, and you provide those reasons to the court. The reasons include everything I've said and everything everybody else has said for the last 6 weeks. But you tie it to the federalization of what took place in the Manhattan court, that is, the reverse federalism, where now the federal government is being affected, a federal election, a presidential election, the entire campaign law process at the federal level is now affected by this one court in this one state. And you got to put that back in the box. And there's only one institution that has the power to do that, and that is the United States Supreme Court. And we're only here because the Democrat Party is so loathsome, conducting itself in such outrageous ways that it is now, in its fundamental transformation of America, it has now devoured our legal system. So our legal system is not really a justice system anymore. It's a legal system. There are lots of corrupt legal systems all over the world. It's a legal system. We have a justice system, and they're not the same thing. The justice system is being destroyed by the destruction of the legal system. I can't think personally of a more compelling reason for the Supreme Court to accept a writ at common law than this case. It triggers every, or virtually every issue that will continue to make its way to the Supreme Court if this isn't resolved now. What are you talking about, Mark? The door is open. Tyranny is here right now. Is every blue state hack prosecutor, whether it's Fani Willis, Alvin Bragg, you've got them all over the country, now free to do what was done? That is kangaroo, star chamber, third world-like courts? And the people all over the country are going to be bound by what takes place in that court? I don't live in New York. I don't live in Manhattan. I'm right now here in Virginia. If I'm not in Virginia, I'm in Florida. I have nothing in common with the politics of New York. That prosecutor wasn't elected by me. That judge isn't my judge. That judge has authority over Manhattan, New York law. Not me in Virginia. Not you in other states. Not over the federal system. If the Supreme Court is going to step in, now would be the time. But they need a petitioner. They need somebody who's going to bring the case to them. Bring it to the door. If they don't open the door, if they slam it shut, you've done everything you can do. You've done everything you can do from a legal perspective. Everything you can do. Well, what about from a constitution? No, you can try and amend the Constitution. That's why I support Convention of States and so forth. It's a very difficult process. It takes a very long time. It's something we need to fight for. But as a practical, present-day matter, legally, we've done everything we can do. The other side doesn't contort itself into a pretzel to try and determine whether or not a court will say yes or no. They just go. Which brings me back to the beginning of the program. I've litigated against these people. Landmark Legal Foundation has fought these people. Other conservative legal foundations have done the same thing. I don't bring experience as a former federal prosecutor and I look at things this way, or a former state prosecutor and I look at things this way, or a professor who teaches theory and looks at it this way. I come to you, and what I bring is experience in fighting these people legally in state courts and federal courts in the United States Supreme Court. They go into these fights with brass knuckles. I go into these fights with brass knuckles. We've won more than we've lost. But that's not the point, is it? If you don't fight, you lose. You surrender. I'm not prepared to abandon the Constitution. If the Supreme Court chooses to do it, fine. If they find some kind of procedural imperfection or defect, that's up to them. I know if I were on the court, don't worry, never going to happen. If I were on the court, I would say, the hell with doctrine. Let's get this case in front of us. We cannot allow this to take place. There'll be plenty of constitutional bases for doing this. We'll work that through. But what's happening right now is the entire system by which the citizenry participates in our government at the federal level is in critical condition. And we are the surgeons, and we need to fix this. That's my perspective. I get very frustrated when I hear other lawyers with different experiences and backgrounds throwing up their hands. It'll be reversed on appeal 100% in 1,000 different ways, just not in time. You're talking about your republic, just not in time? Well, you've just lost your republic. The voters have just lost their equal access to another candidate. And that candidate's equal access to then. Well, I hope this makes sense. I'll see you next time on Levin TV.